Data Security Law and Personal Information Protection Law, Implications and Solutions for Foreign Companies. My name is Mareike Seselberg. I'm Senior Consultant at China Brand IP Consulting, and with me today are my colleague Liu, which will talk about data security law in the first part of the webinar, and my colleague Zihao Liao, who will talk about the personal information protection law today. I will just give you a short introduction of the laws that need to be considered when talking about data security and personal information protection, because even if our title of this webinar implies that we will only be talking about data security law and the personal information protection law, also the cybersecurity law is very relevant for this data security topics. The cybersecurity law is already enforced since 2017, and it is the basis, the fundament for all of the data security and data protection regulations in China. The data security law has come into force in September 2021, and the personal information protection law has very recently, November 1st, 2021, come into force. You can see here we have chosen three colors for these three laws. So on the following slides, everything that's marked yellow is about the cybersecurity law, everything marked green is regarding the data security law, and everything that is related to the personal information protection law will be marked in red. As I just mentioned, these laws cannot really be separated. They work together and they build a complete system of data security and data protection. And the cybersecurity law, the earliest law of these laws, actually focus on this topic from a much more technical perspective. So the aim of the cybersecurity law is to guarantee a certain security of IT systems which are used to process data. Of course, if the IT system which processes data is more secure, the data in there is also better protected. The data security law, which you can see here in green again, is meant to, on the one hand side, promote the usage, the processing of data for innovative solutions, but at the same time also restricts the usage and controls it. And the personal information protection law is obviously meant to protect personal data. It's similar to the GDPR, but my colleague will later on tell you more about this. Also, please remember this webinar is more about data security and personal information protection. So if you're interested in cybersecurity law topics, especially the multi-level protection scheme, you can refer to our YouTube channel, and we have several webinars on the multi-level protection scheme, on how it works and how it can be implemented. So let me give you a short overview of the data security law. So the first point I want to make here is what you have to keep in mind is if we talk about data security or data protection here, we oftentimes mean personal information protection. But in China, and especially data security law, this really means all data. So data security law does not only refer to personal information protection, but also, and actually this law mainly refers to general protection of all data. What you need to keep in mind about this law, or what you need to really pay attention to, are especially the classified and graded data protection that you can find in Article 21. This once again emphasizes that the multi-level protection scheme that we already know from the cybersecurity law really needs to be implemented and is fundament of the data security, other data security regulations. Also, data security management is a huge topic in this law. And something that's probably most interesting for foreign companies is Article 31, which is talking about cross-border data transfer. Regarding the personal information protection law, as I said, it's very similar to GDPR, but you have to be careful because there are some differences, and my colleague will tell you more about this later. One thing I want to give you, or I want to tell you ahead, is especially regarding the vocabulary used in this law, you have to be careful because the Chinese law uses data processor and means the same thing what we in Europe mean when we say data controller. So they don't, they use this word as representative, or it represents the same that a data controller in Europe does. So you have to be careful when you read any text about this law, because the vocabulary is slightly different. Also, this law is has some part about cross-border data transfer, which is very interesting for foreign companies and needs to be paid attention to. But also topics like data localization, prohibition of disclosure, and so on, data disclosure to recipients abroad, and so on, is touched upon in this law. So this means actually that all these three laws bring a lot of need for action for foreign companies. The cybersecurity law is already implemented very strictly in China, and the authorities are controlling it more and more. The main point of cybersecurity law, or the main need for action, lies in the multi-level protection scheme. But as I said, this is not our topic today. So if you're interested, you can check out our other webinars. And for the data security law and the personal information protection laws, there are several actions that need to be taken by companies. And my colleagues will now tell you more about this. So Lilo, the stage is yours.
All right. Thank you very much. Next, I will present the area on data security law. My colleague, Ms. Sisebek, has just given an overview of data security law. And now I will describe what kind of obligations companies have as data processors in the area of data security law, and how they can specifically meet these obligations. I have divided these obligations into passive and proactive obligations, depending on whether the company needs to implement these active measures to meet these corresponding obligations. Passive obligations refer to those obligations that arise after the intervention of Chinese authorities. They always have something to do with national security. For example, the obligation to undergo a national data security review if the company processes important data that may affect national security. And another example is that if the authority demands access to a company's data, the company should also cooperate, etc. However, in contrast to these passive obligations, enterprises need to pay more attention to these proactive obligations that should be fulfilled before the Chinese authorities intervene. Among which the most important obligations are that enterprises should especially establish a classified and parading data protection system and a data security management system, which I will explain in detail later. And processors of important data should conduct regular risk assessments and report to the authorities. Regarding the compliance for the cross-border data transfer, if important data is to be transferred across borders, companies should consider the requirements of their industry regulations and meet the relevant compliance requirements. For example, the important data in the automotive sector should be localized in principle. But if the cross-border transfer of such data is necessary, the data processors in the automobile sector should conduct a risk assessment and report to the authorities. Important obligations among the above are the establishment of a data classification and a graded data protection system and a data security management system, which should be based on MIPS, just as my colleague Marijke Sisebek has already said. Here, I want to make it clear in case that you may be confused. The goal of MIPS 2.0 is to ensure the cybersecurity and the security of your company's information systems, while the data classification and graded system is to ensure the security of all data running on your company's information systems, as well as the data that is in non-electronic form by applying differentiated measures for different data. Companies should classify all of that data according to the industry regulations and standards that apply to them, and then grade this data element according to the level of importance, such as from level 1 to level 4 or 5. Normally, important data and national core data will be graded as higher as a level higher than 3. Currently, there are several clear data classification and grading standards for financial data, securities and futures industry data, telecommunications company basic data, industrial data, and automotive data. But other industry standards are still being developed by the relevant government departments. I would expect that other industries will also gradually introduce their industry standards in the next year, and companies should be kept updated about that. Next, I will talk about how companies can respond to their obligations under data security law. Here, I recommend not to separate these obligations from each other, but to look at them from a comprehensive and dynamic perspective and to fulfill them. That is, to create a complete process of data security management that covers all passive obligations and proactive obligations, as well as ensures the security of the entire data cycle security. Step 1 of building such process is data mapping. Data mapping is the basis as well as the most important step. Here, it is necessary to find out exactly what data the company has, where and how this data is collected, forwarded, processed, and stored. First of all assets, all information systems, and all data carriers, data sets of your company must be identified, and it must also be found out what data is collected and stored in each of these assets. For example, to find out what data is contained in the CRM system, ERP system, etc. This process is also called data inventory, showed in the right upper diagram. Then the process of data flow needs to be clarified, from data collection to data processing and storage. Who controls and manages the data, what technical measures are taken, and then the data flowcharts should be created as shown in the diagram to the right, which shows the process of customer information from collection by the website to the processing by the database and CRM system, and to the assess by the distribution team, and finally to achieving by the database or even being deleted. Once a company has a clear idea of what kind of data it holds, then step 2 is to classify and grade the data according to the relevant industry regulations and standards. For example, in the financial industry, data can be divided into operation data, customer data, business management data, etc. And operation data can be divided into account information, agreements, etc. And agreements also include general contracts, etc. So after this kind of continuous classification and reclassification, then the final individual data elements can be formed and a clear and concise directory tree can be created. Then the security level of each data element is to be determined. That is the data grading. And just similar to the grading of information systems under MIPS, data is also graded according to its impact if damaged on national security, social order, public interest, corporate interest, and personal interest. The higher the impact, the higher the security level of the data element should be. After data classification and grading, step 3 is to set up the data protection system. Generally speaking, this system should include protective measures at the technical level, at the organizational level, and legal level. At the technical level, a number of technical protection measures already exist in practice, such as database audits, etc. The details of these measures I will not explain here, but I only want to emphasize that when selecting these technical measures, company must check whether the technical measures taken are sufficient to protect the data involved, and whether they correspond to the security level of the data, and whether they can ensure the security throughout the entire process of data flow. And at the level of organizational measures, it's important to build a good working organizational structure with internal normative documents and clear division of responsibilities for data security. It will define which department, which person is responsible for which data. For example, according to data security law, companies must designate a data security officer or administrative body for the security of important data. And last, in terms of the legal level, the compliance issue, companies must also prepare some compliance documents for specific data. Examples include data protection agreements with third parties for personal data, risk assessment report for important data processing, etc. And for foreign companies, it's especially important to prepare the compliance documents for cross-border data transfer, because cross-border data transfer would mostly happen to foreign companies. So the possibility of inspection by Chinese authorities is very high. According to the current laws and some drafts of measures and regulations, companies shall prepare the compliance documents mainly for the important data and personal information, such as you should prepare the important data catalog of your company to determine which data held by your company falls into the scope of important data specified by your industry standards. And you should also prepare self-assessment report templates and also documents needed for the government security assessment, etc. For personal information, there is also a list of documents needed, for example, PCI, which my colleague Zihao Liao will explain later. As most of the regulations and measures in the area of data security law are still being developed by the corresponding Chinese authorities, these documents needed will also change with new laws and new regulations as well. You can follow up our YouTube channel and our website to get the most updated information in the following months. All in all, I want to mention again, the purpose of this system is to differentiate the protection measures for different data at technical, organizational, and legal level. The higher the security level of the data, the stricter the measures should be. That is also what the Chinese authority emphasizes. Last but not least, the final step is to operate this system If a company has a complete data protection system in place, it will be able to perform well in the face of inspections by Chinese authorities. At the same time, companies should conduct regular compliance audits internally. If some gaps are found, and they should return to the third step to fix them and then operate the new system. Through these 4 steps, the security of the data cycle is ensured, and as well as the obligations under data security law can be met. Next, I will pass the microphone to my colleague Zihao Liao. He will present the area of people for you.
Thank you so much, Liu Liu. Since the Personal Information Protection Law comes into force, the most discussed topic is the difference between the people and the GDPR. It can be said that most of the contents in the paper are similar to the GDPR. It can be good news for foreign companies because so many foreign companies in China have already taken some measures according to the GDPR. However, I'd like to emphasize here, even though people and GDPR are similar, there is also difference between these two, sometimes even big difference. Therefore, it's very important for foreign companies to know the difference between these two well. And as a processor of the personal information, a company has many obligations. For example, the additional protection for sensitive personal data or security incident response, etc. Such obligations have almost no difference compared with the GDPR. And for foreign companies, the most important is the cross-border transmission of personal information. For better understanding, I'd like to give 2 examples here. The first example is about the cross-border transfer of personal data, and GDPR provides a list of countries that provide an adequate level of data protection, and no additional safeguards are required if the personal information is transferred to such countries. And however, there is big difference in China. We can have a look at the people. For transferring the personal information outside of China, one of the following conditions must be met. There are four conditions. The first one is a security assessment organized by the Chinese Cyberspace Administration, or the certification by a specialized institute, or the third condition is contract with the overseas recipient according to the standard contract, etc. Here, by comparing these 2 different requirements, we can already assume that China is intended to control the cross-border transfer of personal information very strongly. This is also the trend in China regarding data protection regulations, not only about personal information, but all important data and core data. And the second example is about Personal Information Security Impact Assessment, PISIA. Many foreign companies might be familiar with this system because there is also a similar system in the GDPR, Data Protection Impact Assessment, DPIA. But as I said, even though there are similar systems in the GDPR, the foreign companies should be aware of the difference between of these 2 and take the applicable situation of the PISIA as example. PISIA is required for the following cases: processing sensitive personal data, automation, decision-making, or commission, sharing, or disclosure of personal information. The last situation is cross-border transfer, and this situation applies in particular to foreign companies. How to implement the obligations under the people? Let's still take the PISIA as an example here. Generally speaking, PISIA means identifying the various risks related to personal information and then evaluating the effectiveness of measures so that the processing of personal information is in accordance with the law. For the exact steps of the implementation of PISIA, China has already issued a corresponding guidance, and the steps is as follows. A clear data inventory or data mapping must be done at first. After that, risks have to be identified and analyzed. In risk identification, there are several checklists which are determined according to the guidance and are very useful. I will explain them later. In the risk analysis, it should be determined, for example, whether the processing of personal information had an impact on personal rights and interests, or whether the security measures are effective, etc. And finally, appropriate measures and improvements must be taken. Based on our work experience, there are 4 steps in the practice to implement PCIA. At first, project preparation must be done. During the preparation, a project team must be formed. It's basically similar to other projects, and the reason I have listed is, unlike other projects, PCIA doesn't involve just one department, but many departments such as legal, IT, and HR, etc. And when selecting the personnel to form the project team, attention must also be paid to the specific person. When forming the project team, it can be helpful to choose the head of a department or a supervisor of the department to get a complete picture of overall situation regarding all processing activities about personal information. After the preparation is done, then we can start the data mapping. The second step is conduct data mapping to collect information. My colleagues have already explained so much about that, so I will not explain that here. Here I want to emphasize one important point. The company itself plays the most important role during the data mapping process, because only the company itself has the most comprehensive knowledge of all the information in the company. And in our experience, however, the biggest problem is that the company itself is totally unsure how to proceed and what kind of information it should collect, or what kind of information it has already collected. In this case, it might be better to get help of a third party. A consulting company, for example, will know more precisely what kind of information is to be collected when preparing the questionnaires. And a third party familiar with Chinese law can also help avoid mistakes. Once the data mapping is completed, the information needs to be analyzed. In particular, analysis of the sensitivity of personal data, or the analysis of personal data processing activities. And in the practice, analyzing risks is also a challenge for foreign companies, even if they have already taken measures according to GDPR, because identifying and analyzing risks requires considering how Chinese laws and regulations define risks and determine the risk levels. Just using the European standards, I mean the GDPR for Chinese companies, doesn't work. And under the guidance of PCIA, there are 4 aspects to consider when identifying risks. And here I have listed here, there are certainly 4 checklists in 4 different aspects. We can just have a look at them. For example, you should check, are there third-party codes and plugins used which can collect the personal data, or the company has to make sure if there is a high amount of personal data proceed or likely to be processed, etc. These checklists given here are just examples. In the practice, of course, there are more factors to consider. After identifying risks and a comprehensive analysis must be carried out, company must then implement the appropriate measures against such risks. The company is also required to write PCIA reports. Under the people, PCIA report must be kept for at least 3 years. And the law, the people doesn't explicitly state that PCIA reports must be made public, so the company is free to do so or not. However, there are some advantages if the company chooses disclosure this kind of report. For example, the customers of your company can directly know that the company has already implemented PCIA and therefore have more confidence in your company. This is just one example. In summary, I have listed here how China Brand can assist in the implementation of PCIA. It should be mentioned that the implementation of PCI is just one example of the implementation of people obligations. And of course, we can also help to implement other obligations under the people, and you are welcome to contact us after the webinar.
Thank you very much. So I trust that this has been a lot of information for you. So I will try to summarize it a little bit so that you go out of this webinar with an overview of what you need to know. So there are some tendencies that we have seen lately and that we will be seeing or that will continue during the next year. So there has been more regulations during the last year, and we are expecting to successively see even more detailed regulations and industry standards concerning the DSL and the people coming out in the next year. This is actually necessary too, because even though these two laws also contain concrete regulations, but there are still some details missing, which are sure to be defined in more detail in the next year. Also, we have seen stricter controls of cybersecurity and also data protection during this year, and this is a trend that will definitely continue into next year. You can see up here in Tianjin only, there have been 4,084 cybersecurity inspections. There have been 795 interviews and corrections, and 446 administrative penalties in 2021. So up to date. I mean, the year is still going on, so there will be more. And this is also what we see with our clients. There are more PSBs actually actively contacting companies and inquiring for the implementation status of cybersecurity regulations and at the same time data security regulations. You have probably all heard of the case of Didi Chuxing in China, which was subject to a cybersecurity review just prior to their US IPO. And also there's data from the MIT in China about 408 applications that were removed from app stores due to missing or inadequate data protection measures. So we also see this trend continuing in the next year. So especially if you're operating any apps, websites, and so on, be prepared that there will be more controls. So what you need to keep in mind is that all these laws put you into different roles, and you might be subject to one or more of these roles of these laws. So the cybersecurity law defines the network operator. In the data security law, it's a data processor who is subject to the obligations. And in this personal information protection law, it's the processor of personal data. And also there's this CIO, which is a critical information infrastructure operator, also a role that comes out of the cybersecurity law. You will probably have more than just one of these roles. Most likely you will be network operator, data processor, and processor of personal data all in once as a company. And please don't be shocked. The responsibilities listed here look like they are very many, but a lot of them are also overlapping. And yeah, there's actually a quite clear road to take to implement all the requirements of these laws. However, it's important still to go through this list of obligations and to see which of them are relevant for you. Why should you do this? Actually, these laws also come with legal liability if you don't follow them. This might contain, for example, inspections and warnings, which might lead to suspension, termination of service provision. This especially refers to apps, websites, and so on, digital services. There will definitely be fines, and the fines in China are getting higher and higher with every new law. So they're not as low as maybe some are still expecting them to be in China. Also, there might be temporary closure, withdrawal of business permit, revocation of business license in China if you're not cooperating with the authorities in regard of data protection. And of course, you can also be subject to criminal liability in very severe cases. One thing that is not listed here is in case of the violation of, or if the misuse of personal information, you might also be subject to civil liability if a private person files a lawsuit. That also might leave its imprint on the social credit system. So all of the punishments that you might get might lead to a lower score or a bad evaluation in the social credit system, which might then in exchange lead to further punishments in other aspects. So actually, you know now that there are quite some obligations, some requirements in China, but anyway, there are very clear steps to take. So the first step is definitely the multi-level protection scheme in China, which we have not listed on this slide now. And when you have done this, you can start to follow through with the obligations of the data security and the personal information protection. This is pretty much similar to every project management. You will first check which data you have. You will evaluate what data you have. You will evaluate if the measures that you have taken are in accordance with the law or if some measures are missing. You will draft a rectification plan. You will check how to address these problems that we have found. And then, of course, you will implement new measures and monitor if they are effective. This is pretty much similar to the scheme plan, do, check, and act, which we already know from other project implementation. So with this, I would like to thank you for your attention. If you have any questions after this webinar, please feel free to contact us anytime. So that's it from us today. Have a nice day. Bye.